My guest today is Stephanie Rhima, an attorney and founder of Rhima Law. Stephanie has tried over 40 trials in her career, and we're here today to talk about the constitutionality of visiting retired judges. But before we get into that, Stephanie, give us a summary of this case that we're going to talk about today that's in the 325th District Court.
So I'm actually not a family law attorney. So coming into this case, it's a client of mine I've known for about 15 years. So going into it, I wasn't familiar with family law. And so once I got there, there was a judge that was presiding, but I knew that the actual presiding elected judge was a woman. And so I was confused. So I started looking into it and I started learning about the assignments first via the Texas government code and the proper procedures. And that's where I started learning that in the case, those procedures weren't followed and my client was being harmed by it. So that's where it all started.
You filed a motion to disqualify this visiting judge based off of that. Can you briefly describe what followed after?
Yeah, this was supposed to be with Cynthia Terry, the presiding elected judge, but instead the court coordinator was adamant that this was going to be heard by Judge Harris. And so that's when I started wondering, where is the official assignment order? So basically the 8th Administrative Region, they're supposed to basically be assigning judges when the presiding elected judge is unavailable, recused herself. Here, I noticed that the presiding elected judge hadn't recused herself, and that motion for enforcement, I requested a jury trial, which was denied, and it presided with Harris, and he ended up awarding about $15,000 in attorney's fees against my client and also put him in jail. And it was a low amount. So he was very unfair to my client. But then, so I noticed that he wasn't actually assigned, and, doing enough thorough research, I objected to the assignment via the rules, which I objected within the notice of when we actually got the official assignment. That never even got heard. They wouldn't even, the court coordinator was like, this is untimely. We're not hearing it. So then I moved for a motion for disqualification based off of lack of assignments and no authority. And so that's when we had that hearing, and they ended up assigning Judge Wallace, who's another retired judge, to preside over the hearing. During that time, I requested the minutes of the court, and they refused to allow me to basically inspect the minutes, because the minutes of the court is something that attorneys don't actually know about. The minutes of the court is basically the judge's administrative file. So if the judge leaves for vacation or anything occurs in the case, it's going to be in the minutes, in addition to constitutional oaths on file, which are required, because if, as an attorney, if you're going to appeal, you have to make sure you have the minutes of the court. And so Judge Wallace presided over the disqualification. We were in the hearing for about an hour and a half. He ended up denying the disqualification, indicating that the objection via 74.053 was still needing to be ruled on, to which Judge Harris ruled on the motion objection, but the objection was based off of his authority, which he shouldn't have actually been the one to rule on it. That same day, he ended up moving to just recuse himself. I'm currently going to be working to get those orders signed by Judge Harris as void, because he didn't have the proper authority. So that's where we are now.
And then you followed up by asking for their oath of office, or at least for one of these judges. And what did you find?
So just a background, because I know a lot of lawyers don't know this, but there's this Rule 12 request that you can send requesting basically oaths of office, but it's also open records request, where you send Secretary of State requesting the oath of office and the statement of officer. So 2 oaths, and there you give a time span, and because every time a retired judge comes onto a case, before he sits for the assignment, he's supposed to do the oath of office, and it's supposed to be filed with the Secretary of State. So when I was requesting the minutes of the court multiple times, they kept telling me to go to the Secretary of State, which I explained the Secretary of State's one step, yes, but it still should be in the minutes of the court. And I ended up requesting the oaths for Judge Wallace in addition to Judge Harris, and I recently got a response that there are no oaths on file for either of these judges.
Okay. And
And
I
I
please.
also went ahead and let the eighth administrative clerk know. And so Judge Evans also, just so they know that these two judges don't have their oaths, just for future rotation.
I went ahead and printed off. This is important because we're talking about something that people may not follow law very closely, but our Constitution is very clear on this. And I wanted to just read Article 16 of the Constitution. Section 1, official oath of office reads, quote, all elected and appointed officers before they enter upon the duties of their office shall take the following oath or affirmation, end quote. And before I let you comment on that, what that means to you as an attorney, I just want to point out that there's no caveats for retired judges. This applies to all elected and appointed officers, visiting retired judges being appointed in this case. So how shocked were you to find that this judge who came in and had the ability to jail your clients was unconstitutionally qualified on a very fundamental level?
I was shocked because I come from Dallas and Harris County. I practiced in Houston and then also Dallas County. And practicing in the civil courts, the judges follow the rules, and they're, and especially in Dallas County, the judges are, they ensure to preserve the integrity of the court system. And going into Tarrant County Family Court, it was almost like this. I described it as a backroom courthouse in which just basically a judge sits down and he says he's going to rule today, but he had no authority. And so I've learned that, you can either be a de jure judge, de facto judge, or you're a trespasser. And if you're a trespasser, that means you don't have authority, you don't have your oaths on file, and that means that you don't have immunity as a judge. I was shocked because I never expected this. And I think that family law is one of the most important areas because the family, and it can really impact someone's life, and as well as criminal law, because if you're going to execute someone, or, these are things that due process requires that the judges and follow the statutes and the rule of law and ensure that the defendant or the person that's being charged has constitutional rights. And here it just seems that they weren't following that.
Yeah, the elected judge didn't show up. She didn't recuse herself. Just to kind of summarize what happened, the visiting judge was not appointed. Visiting judge, no oath on office, who was not appointed, showed up, jailed her client. Another visiting judge ruled that it was okay, and then eventually, the only thing I think positive that's happened so far is that Harris voluntarily recused himself. Do you think he basically had no choice at this point, or what do you think their mindset is right now?
So basically, there was a Judge Evans of the 8th Administrative Region. He sent an order basically saying, because whenever Judge Harris recused himself, he indicated in his order that this needs to go back up to the 8th Administrative Region for a new judge assignment. But then Judge Evans did an order that basically indicated there is no need for a new assignment order because Cynthia Terry, the presiding judge, has not recused herself. So basically my motion that I filed, disqualification, indicated these facts, and he basically reaffirmed it. But the initial start of this was that Cynthia Terry took a vacation, allegedly, and during that time, Judge Harris was basically assigned for those 3 days. However, it said that if he did not start a trial on the merits, then that assignment was over. It wasn't a assignment where he was assigned to this specific case. It was just during that vacation. Well, instead of because we didn't start a trial on the merits during that vacation time, he basically self-appointed himself to continue on the case when Judge Harris or Cynthia Terry was available. I mean, I went and sat in her courtroom. I've seen her there multiple times. And so he basically did a self-assignment to keep staying on the case. They ended up doing another request for assignment, which all of these requests for assignments that were coming from the court coordinator requesting specifically for William Harris. So essentially that second assignment was just also reaffirming that that original assignment didn't control any authority. But on top of it, I mean, there was no constitutional oaths that I found, but that's not an issue that I'd be raising to the court. It's an appealable issue.
We found a lot of serious procedural issues, to say the least. What advice do you have for folks who go to court and visiting retired judge shows up unexpectedly? Because this happens with criminal, family, and civil courts.
They, the attorney or the pro
Mhm.
se
I guess
party,
either. Yeah, either. Yeah.
they need to object immediately,
Okay.
object that they object to the assignment, and make sure that you're objecting, because if you don't object, they could say you waived it.
Hmm.
So, but on top of that, I think as an attorney, I think you have a duty to represent your client and ensure that the constitutional requirements and procedural requirements are what met. So I think that this is an avenue that is honestly a very strong grounds to get orders that are unreasonable to be vacated. So I would suggest doing the Rule 12 request and open records request for the oaths of office. If there's an associate judge on the case, request via Secretary of State, their oaths as well, and then also request from the county court their applications, because if the county courts fail to ensure that associate judges are have the authority to sit and they fail to do so, then they could be responsible for the harm caused to my client, such as the attorney's fees it's taken to fight this. I mean, if Cynthia Terry sat on the case and was there, then he wouldn't have had to incur all these expenses of me
Yeah.
fighting for his rights, because we were supposed to have a jury trial or a trial with Judge Harris, and this was supposed to be a final like a modification of child's basically sole managing versus joint managing conservator. So who was going to get the child? And so this was an important issue, and I just wanted to ensure that my client had a fair trial and a fair proceeding. And so I would suggest to lawyers to actually look into it and ensure
Okay.
that the person sitting on the bench is actually has authority to do so.
Good advice. Yeah, make sure they have an assignment and an oath of office on file. I'll mention real quickly because last year we did a lot of reporting on Daryl Coffey, and he had no oath of office on file. He was not a senior judge. He was assigned as a senior judge falsely to 100 criminal cases, including people who are in prison right now. And he did not live in our region. And after we reported that, he was removed from the list of senior judges. So the real victory would have been a retrial for all those people. But when you bring these things to the public's attention, at the very least, you can get these judges removed from the list and hopefully, prevent them from doing this again. So,
Yeah,
uh,
but also I think it's more of like if enough attorneys go at this avenue, which from my
mhm,
side, it's the most strongest avenue, instead of
mhm,
arguing like poly factors or, because the judges in family court, they have a lot of discretion. And so that in itself is enough to make an attorney know they need to make sure. And so if attorneys start, requesting this and moving forward with this, I think it will preserve the
okay,
integrity of the court system, because they'd know these attorneys aren't going to let us get away with it. So we need to make sure we're following the right procedures for assignments and associate judges.
okay. Well, plug your website or any social media you want to for your law firm.
Oh yeah, so my law firm is Rhima Law. I started it this past year. I'm actually an insurance defense attorney, but I've also have been doing family law just because I've kind of gotten
Mhm.
into it and I seem pretty good at it. So,
You are.
but yep.
All right, cool. Well, Stephanie, thanks for your time. A quick disclaimer, Stephanie represents me in an unrelated case in the 231st. She's an incredible attorney. Check out her website. We wish you the best of luck, and thanks for helping make Tarrant County a little bit more honest.
Okay, thank you so much, and I look forward to hopefully keeping the courts in check and.
Yeah, we hope you do. Thanks for your time.
Okay, thanks.